All right, so maybe we can begin. And I just want to ask Lynn, maybe you want to head up this discussion so we can begin and we can get going.
Hi, everyone. Okay, so I think today we've gathered so that we can comment on that letter that we want to send collectively to the landlord and get consensus on it, whether we're going to send it individually or whether we're going to send it as a collective letter to our landlords. I think that is the primary objective here.
All right, excellent. So this letter is the one that was in fact circulated, and it is the one that you were asked just to consider and to give some feedback on. So possibly we could go through it line by line, and I could ask you for your comments so we can actually agree on any and all changes, and then obviously talk about the process.
I'm fine with that. Thanks, Arthur.
Okay, so who would like to give comment first? Just to remind you, the principle then is that once we've finalized the what's in this letter and how it looks, we will then be asking you to sign the appendix to the letter, because the letter does refer to an appendix which lists the tenant on whose behalf this application is being put to the landlord through the managing agent to consider. Um, I'm not certain, Lynn, if you know the total number of tenants within the Cape Quarter.
I don't know offhand, no. Perhaps Philip knows.
Philip?
Unfortunately, I don't know either.
All right. So I think what we'll do is I will then send you, once we've completed the letter, I will then send you a schedule that we're just going to ask each tenant to actually sign and simply email back to us so that we've got each person's signature. Just a form. In fact, we'll do it as an online Google form that I'll prepare. So you'll just go online, you'll fill out the Google form, and that'll then constitute you asking us to include you in the schedule. I keep forgetting that we can't physically meet face to face. And so that on that basis, we can actually constitute the schedule. We'll attach the schedule to the document, and it'll then formally go out to your landlords, and we'll await their response. The important thing is to peg it so that they need to respond in one way or another to us, and they'll then be required to respond on our terms, which are not terms, but on our proposal, which I think is critically important. So let's maybe just read through the letter so that everybody's comfortable on a sort of paragraph by paragraph basis. Dear landlord, so it's first of all without prejudice, request from your tenants during the COVID lockdown. That without prejudice is quite an important component, because what it basically says is that this is an exploratory discussion we're looking for, cannot be held against us, and we certainly don't want you to at any stage act as if there's a legal obligation arising from this letter until such time as we agree on what that legal obligation should be. Dear landlord, this letter is written to you in good faith and in the hope that we can mutually avoid resorting to legal means to resolve a matter which has resulted from causes beyond the control of either yourself as landlord or our members as your tenants. Number one, in the introduction, we simply say why CITA exists, but we also talk about Schedule A, which is attached here to list your tenants who are ordinary members of CITA. So that's critically important that we complete Schedule A. Number two, our request. As you're aware, unless specified in Schedule A, we're either essential services or that part of their operation is in lockdown, the balance trading under essential services certificate. Your tenants listed in that schedule are currently in total lockdown. So we're basically saying to them that unless we specify that they are essential or part essential services, then that tenant is in total lockdown. When I send the link to the Google questionnaire to you, I will ask you to indicate if you're in lockdown, if you're partially essential services or fully essential services. As such, they have either fully or partially ceased trading for the period of the lockdown, or some or all of their employees have been temporarily laid off due to the lockdown. I'll get that information, by the way, from the questionnaire that I put out to you. Our members are in full acknowledgement that for the period of the lockdown on a month-by-month basis, the following must be paid by each tenant to you in terms of the existing lease agreements. Now, ladies and gentlemen, I have received sort of comments from some of you that some of these are problematic and you wouldn't want to pay them. So let's just complete this list so that you are comfortable with what we're saying. So what's included so far is rates, taxes, municipal services, including electricity, water, and sewage, security levies, and insurance levies. As the first section where we're actually tendering these payments, is there anything that should be added or anything that should be taken out from that list?
Ivor,
Yes.
just, I mean, I think either Joseph or myself can talk on this, but you know, as my understanding is at the moment, I mean, you know, and I know it contradicts what I said the other day regarding, you know, why we be paying these, you know, rates and taxes and utilities and so on and so forth. But I mean, if we just take just a full step back and look at the current situation, is that we have been fully advised to not trade whatsoever during this time. So we are not enjoying our property that we trade out of, nor are we enjoying the rates, the taxes, the municipal services, the security levies and insurance levies. Now, I know, you know, it kind of opens up a bit of a can of worms because, you know, Cape Quarter should continue to you know, continue trading, but on the other hand, we're not able to enjoy those services. So I don't know. I mean, I want to open that for comment and see, you know, what's everyone's stance. You know, is the landlord in full breach of contract of their contract or their lease to us because they're not providing any of the services or allowing us to enjoy any of the services through a forced lockdown?
So can I answer that by saying this, that conventional wisdom is that there is shared risk here, that neither of you or the landlord are responsible for having shut the shopping center down, and that you have a lease which essentially implies that you are partners in the process of wanting to preserve the shopping center until such time as the lease is in fact cancelled. So I think what's absolutely critical.
Sorry, can I interrupt there? Can you please mute when you speak, because there's a lot of background noise coming.
I've just muted someone's microphone, so hopefully that'll cut it out. So the bottom line is there's shared risk and there's shared responsibility. And ultimately, at the end of the day, if there is a dispute and if there was a legal dispute, what we would need to prove is reasonableness. Now, there can be no question that these expenses are expenses which are incurred irrespective of whether the center's locked down or not down and have to be paid. However, and we make this point later on in the letter, that in fact, all your landlord needs to do is knock on the municipality's door and they will get concessions. They'll either get a rates holiday, which means that there'll be a discount to the rates that need to be paid, or alternatively, they'll get deferment, which means that at a later stage after lockdown, they will owe the money, but the money can be paid over a period of time to be negotiated with the council, and most councils are very flexible in that regard. We actually make the point that the landlord needs to prove to us that they've made application to the council and needs to report to us on the response from the council, because ultimately that's your shared risk. You own those rates and taxes that you're paying, and because there is deferment possible and all those other good things possible, you own any solution rather than your landlord owning the solution, because collectively you guys are paying all of these expenses and your landlord's not paying these expenses, except possibly for some of the common areas and what they occupy. So the point that I'm trying to make to you, ladies and gentlemen, is this, that we will be adjudged by the reasonableness of our proposal to them. And I can guarantee you that if we withhold these costs, or, you know, if we can't make, for example, an argument that insurance levies and security levies are traditionally included in the rental component rather than these components, but that if we withhold the rest of the stuff that is legitimately payable now, we will be adjudged to have not made a reasonable proposal to them, and therefore they will either then be able to rest back on the PIG's proposal, or alternatively simply then try and say that you owe them the rent. The one of the arguments we do make later on is that if you as a tenant are not able to make these payments now, that the landlord should agree that you can defer these payments down the line. We do make that argument. But I would significantly appeal to you not to withhold these components of your lease commitments.
Sorry, if I could just interject, I agree that we do need something to put on the table, and that it's not reasonable, but in the light of us trying to gain what we can. But yeah, I was sorry, you actually answered my question, because although many of us could pull out the rates and taxes and everything for April on the basis of how bad March was and the fact that we missed a month end, we wouldn't be able to do it for May, like when we get back on the 1st of May. And if we're not back on the 1st of May, we won't be able to carry on paying operating expenses because there's no income coming in. So yeah, deferred payments. But the other thing is just knowing landlords and how they do things in different centers with different companies, because I've been through quite a few, is that they're probably going to load those prices. And I don't know if there is, as you said, some way that they could prove to us that they've tried their best to do what they can to lower those costs. Yeah.
So Lana, let me say this to you. There are a couple of things here. And in fact, the block release regulations make it very clear as well. Number one, they cannot vary the rates and taxes from your previous bills. That's the first point. Unless the council has done that, in which case all they're doing is passing that on to you. But ordinarily, they cannot change the prices because that price fixing has been declared a criminal offense, by the way. So that's the first thing. Second thing is there are regulations in place to say that councils can't charge interest or invoke penalties by missed payments at this stage. And that's also critically important. Your landlord can't then charge you interest or invoke penalties for any missed payments at this stage. So in answer to your question, I think reasonableness does prevail, and there is now a legislative framework making it impossible for them to act unfairly to you. The other thing, of course, that we wanted made very clear about is that where there is deferment which is incurred, your landlord can't charge you interest or penalties to be able to defer. And we'll talk about that a little later in terms of the extension of lease agreements to cover anything which is incurred by deferment. But we'll talk about that a little later. What I'm looking for at this stage is in principle agreement that what we should be tendering is at least the rates, taxes, municipal services, and security and insurance levies, because generally those are what are charged for as standard operating overheads, unless you're aware of other operating overheads, or unless you're aware of the fact that traditionally in your rental statements, you're not charged for security, not charged for insurance, and therefore we shouldn't stipulate that now.
Sorry, Ivor, it's Joseph here.
Hi, Joseph.
In principle, I have an objection to that, and I've discussed this thoroughly with Tony after our last meeting. I respectfully disagree with the view that there is a shared responsibility here. I'd like to propose that, or my point of view is, at the end of the day, it's like any other building. Let's take my house. I am essentially responsible for levies, for taxes, for everything as the owner. So in this case, the landlord is responsible for doing that, for paying that. Whether or not, essentially in a contractual agreement, we could agree that it's a one price. How they structured the lease, saying, okay, rental component is X and then the rest is Y, Z, A, B, and C, that's irrelevant. At the end of the day, it's all part of one payment that needs to be made to them. So now for me, the question arises more as a matter of, why do we need to pay for something that we are not enjoying? And it's not my responsibility to pay for the landlord's rates and taxes. It's their responsibility. So I only agreed to do that while I'm enjoying the benefit of the contract. But at this stage, like I submitted last week, and I think I would want to relook at it, is this thing about the impossibility or the supervening impossibility of doing the contract. So why is it that we need to pay for that? And take my example, Oxygenate, our lease ends anyways in January, and we're not planning to renew. So let's take we come to an agreement and they're going to extend it and they're going to defer it. Why should I pay now in January, February, March, keep on paying stuff that I'm no longer enjoying at it? And the reason we're paying for those levies, security levies and stuff, is because they're providing a service for us. At this stage, it's just impossible for them to do it. So my question is, why are we putting ourselves in that situation of suggesting that, when essentially for me it's saying, hey guys, what are you guys doing that is in your power to abide by the terms of the contract, which is you giving me how do you call it, unrestricted access to enjoying your property. They're doing absolutely nothing except charging us and wanting to charge us. So my question is, why are we not trying to tell them, listen guys, this is a different story. We're not the ones that are in breach. We want to pay you. What are you doing to allow us to make us able to pay?
Okay, so I think what's also very important for you to consider is this, and that is that you have a contractual obligation, whether you like it or not. You have a contractual obligation, and in terms of that contractual obligation, in terms of your lease, there is a very, very clear obligation that you have to be upholding in terms of this particular issue, which is that you share joint responsibility, and you've accepted upon yourself the responsibility and accountability. Now, you can argue, but hold on a moment, it was because we were buying a product or a service which was insular and was allowing us to trade. This is not allowing us to trade. Their argument is going to be, well, it's an intervening impossibility they couldn't control. And from a legal perspective, they have a legal right to request of you that you do make these payments, whichever way you look at it. You know, you're not. I honestly do not believe that you're going to manage to get out of that particular claim with the argument you.
But on the same token, I have the claim to say, well, you as a landlord have the obligation to give me unrestricted access, which you're not giving me.
Okay, so they're going to obviously argue intervening impossibility because of the lockdown, and they will be entitled to argue that. You know, I suppose.
And that's exactly my point. Why are we not arguing the same thing and saying we cannot pay rent because of an intervening or supervening impossibility?
Well, we are going to say that.
So therefore,
I mean, that is part of our argument. But there has to be, if you cannot demonstrate in good faith a sharing of accountability and responsibility, then you are weakening your own position to claim the moral high ground and the contractual opportunity, if you want, to be able to enforce this kind of a this kind of a concession from your landlords.
Understand.
You know, I know you're only playing devil's advocate, and I fully appreciate that. But I do think that you need to, in this particular set of negotiations, we need to be very specific about if we want the battles that we're choosing, because some of them, you know, we will lose if we choose to make an issue on every point. And I know it sounds petty from my side to say that, or rather, I know it sounds conciliatory and possibly too conciliatory to say that, but I think we just need to be very, very careful about what we choose to battle on. I think we've got a very strong moral battle that can be raised on the rental side. I do not believe we can raise that moral battle on the operational side.
No, I understand. My question was more about why are we proposing it instead of letting them propose it?
Well,
yes, but I understand.
Yes. Sorry, who's that?
Lynn.
Oh, sorry, Lynn. Yes.
So in this list of things, it's the rates, it's the taxes, it's the municipal services, including our electricity, water, and sewage. That is of the common area as well, security, levies, insurance.
Yes.
These are things that cannot see us, and I don't think we should try and negotiate or try and squeeze on. Things like operational costs are not included in this, unless it's on the next page. Operational costs, marketing fees, are not included, and I think that's where we can maybe.
Well, we do. As we'll read through it, you'll see we actually do not operational costs, because these, by the way, are regarded as operational costs, except for the ones which are included in the rental component. And importantly, and I just want to see if I can quickly do something here, if I can remember where the devil I put this document, but I just want to see if I can find that pigs document. Just please give me a second, because I want to show you how they define, here we go, how they define rent. I hope you can all see that on the screen. But what's very, very important is the definition of rent. Where is it? Very, very important.
So the operational costs I'm talking about are for their staff costs to run the centres. It's actually what I would say is the managing agent's fee.
That's included in their overheads. We don't pay their overheads.
Well, we build individually, as far as I understand it.
Just explain.
Am I correct? Well, we have an operating cost that we get billed separately, and we get a marketing fee that we bill separately. When I say bill separately on the same invoice, but it's not part of our rental. It's not incorporated into the rental.
So just explain how how they talk about their operating costs.
So in other words, I get my invoice, and it will have rental, it will have water, utilities, rates and taxes, and then it'll have an operating cost, and it'll have a marketing fee. And those are all separate amounts. So rates and taxes, utilities, as we've just discussed now, I can understand us having to pay those, and I really don't see how we could wangle our way or use it as an opportunity to not pay.
Okay, so
but I do think.
Sorry, Lynn, can I just say this? Sorry to interrupt. I just got excited when I found the component. Let me read this to you from the PIGS proposal. So the Property Interest Group proposal. It says rental includes rent, operating costs, parking, and parking rental, but excludes rates and taxes recovery and utility cost recovery, as well as insurance, which all tenants write. So that's the PIGS proposal. That rental includes rent, operating costs, and parking rental. So my recommendation is that we actually leave it out of this. We don't refer to operating costs. If they come back and say operating costs should be paid for separately, we go back to them and say that in the PIGS document itself, and you're a member of the associations which make up the PIGS grouping, operating costs and parking rental are included, by the way, in your rental costs.
Yeah, I don't know if that'll work because our leases actually specify it differently, but this explains a lot. This explains exactly why they've come back to me saying they'll accept. This was before we'd put this thing together and I'd even started chatting to you, why they suggested, yeah, we'll extend your lease by an extra year at a accelerated rate of, or escalated rate of 11%, but now that actually includes the operating costs. So yeah, suddenly it's all starting to make sense. Okay.
Good. You know, I really apologize for sounding so conspirational, but I can tell you that there has been a lot of engagement at SAPOA. There's been a lot of engagement within these associations before they came out with these proposals. And the engagement was first and foremost principally about how they can make sure that they minimize their own exposure in the process of making these proposals to the tenants. All right, so let's carry on then. Number one. Okay, so number one, these payments will be tendered subject to the balance of this request to you being accepted and agreed to, subject to a weekly report distributed to our members indicating what efforts have been made to enter into an agreement with the municipality for payment holidays and deferred payment terms for these charges. CITA reserves the right to pursue against any landlord who obtains relaxed terms of payments and payment discounts and holidays, but does not transfer these benefits onto our members who are making payments for these services in good faith. Number two, in tendering the above, we also request that you consider on a case-by-case basis our member application to you for deferment of these charges, should the tenant's current cash flow not allow them to make these payments to you. We would welcome the opportunity of engaging with you further on conditions, criteria, and repayment terms which you would choose to apply in this regard. So we're saying that even for these things that we're agreeing to pay, if we cannot pay, if we don't have the cash flow for it, then please, we're asking you to defer. Now, the precedent has already been set for deferral because, again, I'm just going to quickly see if I can go back to that PIGS thing again. That's a nasty acronym, but anyway, I mean, it's there. So let me see if I can go back to that PIGS thing again. Where was it? Here it is. Because in the PIGS thing, you will see here that they're actually saying, so they're talking about 35% to 100% rental, and then further potential relief could be in the form of rental deferments. Now, what's happened is that if you go down, I just want to see where they've actually made that distinction. If I can find it here. If you look here, they're talking here about essential services, but the principle has been set where they're saying 35% rental discount and 15% rental deferment, which basically then means they're in their own rules as pigs, the property industry group, they're making allowance for deferment of some of those expenses. And I think that we should be riding on that to the extent of saying that we want to use that opportunity and let them come back and say, sorry, we can't allow deferment for a variety of reasons. And they might be legitimate reasons, but we're not obligated to accept those as legitimate reasons. That's the point. Is that all right? Can I continue? Hello?
Yes, Ivor.
Okay, sorry. All right, so on behalf of its tenants, CITA disputes the needs to either pay the marketing levy or any parking levies which may be applied. It is CITA's contention that there is no value to be derived from paying a marketing levy during the lockdown period, and that should there be a need to engage in marketing activities, that cost should be absorbed within the operational budget of the property business. In simple terms, as the client of the property owner, our member has entered into a lease for the rental of a unit in a property that has acceptable footfall, is properly maintained, and is attractive to destination clients and passing trade within the complex. Rentals received should more than compensate for creating such a framework, which then becomes attractive to tenants to invest a large proportion of resources in to set up shop. As for the parking charges, it goes without saying that our members refuse to pay any parking fees for parking spaces that are not able to be used. Any other agreement would amount to unjust enrichment at the expense of our members. So that's the first component that we are tendering payment on. Any comments about that before we carry on with, I suppose, the more interesting thing, which is the rental payment itself?
Yeah, we're happy with that.
All right. So now we get to, as I say, the more interesting thing, which is this thing here, which is rental payments. Now, as the businesses of our tenants are closed due to the lockdown, there is no benefit to be derived from occupation based on the clauses and terms contained in the original lease entered into. The benefit is simply not there to be derived. Therefore, our members, your tenants, are not in any position to earn income or pay a percentage of the income in lieu of rent. CITA is, however, encouraging our members to offer 10% of the current monthly rental charge in good faith and as a sign of respect to the landlord and acknowledgement that while our members are severely impacted on by this lockdown, so are the property owners. Now, I have received a significant amount of pushback on this proposal, ladies and gentlemen, where in fact the majority of consensus is let's maybe offer 5% and let them come back on the 5% because we know they're going to push that, or let's offer nothing in the knowledge that they're going to come back and try push the 35% to 100 component and then negotiate from there. This is simply a non-sally. It's been put in the document to say, what do you want to do about this notion of either offering something or offering nothing and then leaving the ball in their court?
I think we leave it in their court.
I think we don't offer any monthly rental. If you're not generating any income, how can you pay a rental? I think it's more than sufficient that we're paying the utilities for the building and that type of thing. But I don't think an actual rental of any sort is can be charged at this time or even be offered.
Any other question or any other comments in that regard?
Yeah, my understanding, chatting to people that are property owners, is that one as a family member is basically saying don't pay anything. I'm talking about in terms of rental. Don't pay anything because the big guys are not paying anything. And again, you know, we end up paying 20, 35% of our rental, and they're not paying anything because they can afford to not, because they can afford all the big lawyers. and again, it's about the small guy subsidizing the big guy once again. So my feeling is I don't think we should leave it to them to just put a proposal to us. That I think we should just say we're not paying rental and then see where it goes from there. But that's just my thoughts.
So then what we'd do is we'd take out that last paragraph like that, and then we'd say your tenants are not in any position to earn income and pay a percentage of that income in lieu of rent. Full stop. Pay any percentage.
Agreed. I don't know if you guys are aware of, I mean, Dis-Chem is actually trading as an essential service, and they're earning income, yet they are not paying any rental. They've refused to pay rental, although Clicks is paying rental. So if a big company like Dis-Chem, who's even trading at this time, is not paying rental because they feel that they're not earning enough, they're basically earning enough to carry salaries, etc. I mean, and they're trading during these times, they're not paying any rental. So why should we offer any rent to our landlords if we're not trading at all?
So let me say this to you in that regard, and you will have seen this from Truworths, you will have seen this from all of the groups. What tends to happen is that they will begin by an opening gambit, and Dis-Chem's opening gambit is, hey guys, we're not paying anything, knowing full well that they will get into a situation eventually where they will have to negotiate and they will have to agree. So what you've read about Dis-Chem and where this thing ends up is going to be two completely different. So how do we know that? We know that principally because we've seen that with the Truworths group, we've seen that with the Pepcore group, we've seen that with the Edcon group. They all start by saying, well, we're not paying anything. And they all know that that will be moderated. And it will be moderated the moment they actually sit down around the table and get into a room. And the important thing to add here is that you know that it doesn't matter when that happens. It might not happen immediately, but it will eventually happen. And when it does happen, it will happen in a way that will cause some kind of a compromise. I think that's very important to understand. But I agree with you completely. Let's put that particular ball in their court, where we actually say to
Ivor, can I just make a point as well? I've verbally successfully negotiated with my other landlords. I did mention this last time, for 100% rent reprieve during the lockdown period on the rental component, and then that would get either tacked on to the end of the lease, or it would be serviced as an AOD. And then for the period of 3 months after the lockdown has finished, and I mean, this we might still have to flesh out just to see how the viability, but to only pay a scaled up version of 50%, perhaps for 3 months, or as you've said, 35, 50, 75. But the principle is that I spoke to a very big property group, a lot bigger than Tower, and in principle that was accepted. So my personal feeling is that for us as non-essential services, that we shouldn't offer any rent component whatsoever, because we also are not 100% sure if and when the lockdown is going to be extended. So anyway, that's just my 2 cents worth.
So basically, we're in agreement then.
Yes.
Hello.
Yes.
I just think, sorry, just lastly, and I'll shut up. I think it might be slightly short-sighted to stipulate specific dates, as you've done in your point 1, 2, and 3 with May, June, and July, and this is what we're going to do, because we don't actually know.
We'll come to that in a moment, because in fact there is provision after that to say that if this thing is shifted with an extension of lockdown, then these dates shift out by the same period.
Okay.
Yes.
Just coming back to the 10% that you were suggesting that we offered to pay as a percentage of the rental.
Right.
I think it is a good idea to give them some direction as to where we would be prepared to go, because I doubt very much that they're going to be happy with 0%. And in my case, they'd come back to me saying they wanted 20% for April, in return for a 12% addition to the lease, So, yeah, I don't know. Personally, I don't think we're going to get away with no rental. just judging how they responded to me.
So I think that you've also seen from Lynn's perspective that they've come back and said that if we make any concessions, then those concessions will be related to an extension of the lease. And if that's for another month, it'll be related to another 2 years extension of the lease. So, you know, we've got to be very careful to exclude anything other than any kind of an extension, which we know they're going to insist on, but on our terms, if at all. And I think that that's an important consideration that we need to think about. So let's just carry on talking. So we've taken off the 10%. In this regard, we're pleased to see relief being offered by banks, financial institutions. Some people have felt we should take this paragraph out altogether. In this regard, we're pleased to see relief being offered by banks, financial institutions, which will, we believe, go a long way towards assisting the property owner in riding out this lockdown. We also encourage property owners to speak to your insurance companies to determine what insurance cover you qualify for in the category of business interruption or loss income, subject to you having accommodated for force majeure and acts of God. Now, the reason I put that in is because that's what they're saying to some of the tenants that they're dealing with. You know, you guys are in a pickle because you didn't properly take care of your insurance policies. And this is a subtle way of reminding them they're in the same pickle. CITA is pleased to offer, now we might take this out. CITA is pleased to offer advice and assistance as a sign of goodwill to any property owner who may wish to consult on the subject, because that is really, you know, possibly going a little too far. And you'd need to decide, are you comfortable with that being in an offer or not?
I think I'd remove the last sentence. It just basically we're starting to sound like mediators, and we're losing our stance.
Absolutely, absolutely. But are you comfortable with the rest being left in?
Yeah.
All right, let's move on.
Yeah.
Okay, so D. Now, recovery after the lockdown is lifted. If lockdown is lifted at the end of April, CITA maintains that it'll take a minimum of 3 months for our members to fully recover and build their businesses back to where they were in January. For this reason, we're requesting a staggered schedule to be applied.
Sorry, I think maybe instead of fully recover, partially recover?
To somewhat, should we just say somewhat recover?
Yeah, not fully, because there's no way we're going to be fully recovered.
To somewhat recover and build their businesses back to where they were in an attempt to build their businesses back, let's say.
Why not attempt to recover?
Sorry? Oh, all right.
What about attempt to recover?
Well, there you go. An attempt.
Oh, sorry. No, I mean,
I agree, okay. Actually. I agree.
To build their business back to where they were in January. For this reason, we're requesting a staggered schedule be applied to the rental payments for those 3 months. Now, just before we talk about the specifics here, let's look at the next paragraph. For each month that lockdown is extended, this period of staggered repayment will be pushed out by an equal amount of time. So generally, in terms of D, any comment?
Hi, it's James here. Just a little comment on this for any sort of restaurants or businesses that hold a liquor license. As everyone will know, before the lockdown went into place, the government put restrictions on trading with regards to businesses that sell liquor. And a large portion of, obviously, our income is derived from people getting happily pissed. So the question I have on this is, you know, for the restaurant portion of people who are members of CITA, so like myself and Yumshis and bootleggers, we obviously might face a situation where we get back at the end of lockdown. And again, we're sitting under restrictions of, you know, can't sell alcohol past 6 o'clock of an evening, plus the weekend restrictions. But furthermore, there might be a restriction on the number of people that we can hold in our venue. So if they stick to the 50, including staff, then obviously I'm way down, you know, sitting at, you know, a third to 40% of my capacity as a business. So how could we incorporate something into this, or should there be a separate schedule just to exclude us from normal retail?
I don't know. What would you want to suggest?
Well, there needs to be, I mean, for me, if they come back and if we start trading again, say 1st of May, we can start to open again. You know, if the government comes back and says that there is a restriction, then those restrictions need to be taken into account, and therefore the recovery period has to be extended out further. So instead of there being a 3-month recovery period for us with a liquor license, we're looking at essentially a 6-month period, because they will come back and obviously restrict the number of people that you can have in a venue, and that's going to have a huge impact. So as long as they have that, I'm only utilizing half of my venue or a third of my venue.
But I think, sorry, it's Joseph again. I think that would apply in general to the number of people allowed at the shopping center. I don't think now we're all we'll open and everybody can go in joyfully and be all over the shopping center. So perhaps it is a good idea to add based on restrictions, because if you take any other, even at Woolworths, they're letting 20 people at a time. So take the Pilates studio. A class is 20 people. They're only going to allow 20 people at a time, and we're in the same boat. So I think it should be in general for every retail.
Joseph,
a clothing shop.
Let me read this to you. So SITA maintains that it will take a minimum of 3 months for our members, up to 6 months for those tenants who have significant additional restrictions imposed on their trading ability, to somewhat recover and attempt to build their businesses back to where they were in January 2020. That sort of takes care of not only the restaurants and alcohol issue, but everything else.
Just one other thing. We do all realize that, obviously going into, once the lockdown is lifted, the economy is not going to be the same. So with regards to obviously social distancing, like you're saying, that there only going to be a restricted number of people in at a time. Plus, the economy is going to be down and people's spending capacity is going to be down, which doesn't mean that we're going to recoup as quickly as you hope. I think this recuperation is going to take much longer than that. And I see Lana's just also mentioned tourists. I mean, we are in an area which relies heavily on the tourist industry. And that's not just going to boom all of a sudden once lockdown is lifted.
Yeah, no, absolutely. I'm completely in agreement with you. So does this change, or does this paragraph then sort of cover that eventuality?
I think the schedule of proposition offering percentage of rental is. I think we committing too much to paper too early, because we don't know what the dynamics and the outcomes are going to be. As we are entering a global recession with social distancing. I mean, reading stuff. I mean, this thing is going to peak in September, January. I mean, who knows what? I've been speaking to people in Germany, the States. I mean, everyone's dynamics are different. We don't know what our government's going to choose to do, and we've also got our own socio-economic dynamics in this country. So, I'm nervous committing pen to paper and having to retract afterwards. Might shoot us in the foot.
I hear what you're saying. Basically, guys, I'm
sorry, Arthur, is there not? Sorry, I interrupted you. Is there not a possibility of looking at a turnover-based rental? Because I mean, that's the real crux of our turnover and what we can afford to give proportionately to what we bring to the table.
Sure, you can make that. So, for example, you can.
I think that could need to be on a tenant by tenant basis, because we will not. We won't agree to turnover-based rental, and nor will I. I won't be showing my books to the landlord. So I think. I mean, that could be an addendum that could be discussed individually with each tenant, just to safeguard everyone's interests.
But how about moving the May, June, and July to a 6 months, basis, and reducing the front of it? So not 35%, but make it down to like 10% there at a lower amount, and then build up to the 75% at the end of the 6 months, which gives all of us a little bit of room. It gives us some wiggle room. It gets us through the winter period, which, let's face it, is going to be horrendous for us this year. And then, we're looking at the sort of, leading into the summer months where hopefully people will be recovering to a certain degree.
So
is it not better to say that, we would be requesting a staggered schedule be applied for the rental payments, and leave it at that, and then let's see what the landlords come back with, instead of proposing all this stuff straight off the bat? It'll also give us a little bit more negotiation room to see where their standing is once they come back with it.
except that we would need April no rent because we're not there. So that needs to be included. Not that they then come back to us and say 50% for April. Or, I don't know. That's what they'll probably do.
No, we already agreed that during the lockdown there would be no rental paid. But what I'm saying is, once the lockdown is lifted, instead of giving a staggered schedule as to what we prepared to pay or potentially prepared to pay, just say that we're requesting a staggered schedule to be applied for the rental payments and leave it at that. And then let's see what they come back with, because then we actually understand where they're coming from, because we might be proposing something here that they might be expecting a little less, and we're offering 20%. They'll be going like, yoo-hoo, where we could have actually been offering 10%. So it gives us a little bit more to go.
I was also offered what Lynn and Philip were offered, so I can tell you what it is. It's 20% for April, and it's 50% for May, based on signing a 3-year lease. So they're not going to come back with much better than what we're offering.
We were actually told to please continue paying our rent in full per normal as we do, and once they had a group discussion, they might pass a percentage credit, and they were talking with us they were talking about 20%. They wanted us to pay your money,
and then they'll have a group discussion.
They asked Peter and I to keep paying in full as we do, which we haven't done, but that's what they requested. And then they said they would have a group meeting and we could expect a credit of about 20%. So I'm not really happy to see what they're going to offer, because there's no way that they will offer us percentages as low as 10, 15, 20% from what they were negotiating with us.
Once you pay your rental, they will not credit your account with that. They'll just take it as your rental.
Absolutely. That's why I just said, because my experience with them on a whole lot of other issues is one of no trust. So I was just going to hold back. And I felt that they needed to come back to everyone with the same message, because I know they've been kind of doing backdoor deals with everyone else.
Sorry, Iva, I heard you said something the other day on another meeting that applied to me, and I just wanted to bring that up. But we do have a debit. I don't know if it's the debit order or the stop order, but it's the one that we can't cancel. And I've asked them on numerous occasions to cancel it and to confirm once that's done for the balance of my lease. And they haven't confirmed that they've done it. I actually pulled the little money that I did have in my account out to save it for my staff, so that they couldn't get it, the grubby little paws on it, and they did try. So it went off and then it bounced. So I don't want to even put any money into my account, because the last people that I want to have any last money that I have is them. So
Lana,
I don't know where I stand.
Lana, also, I've got a direct debit, and what I did is I phoned my bank after the direct debit went out for the rent for this month, and the bank clawed it back for me at a fee. So it came back into my account, and then I cancelled the direct debit with the bank. And FNB were really happy to do that on my behalf.
Okay, thanks, James. Standard Bank wouldn't do it for me. They said that I needed 5 days before to know the exact date, the exact amount that was coming off, and then I could request it to be returned. But I'm going to need to try and take it further.
Yeah, I mean, they did the same to me. They wouldn't do it unless it was 5 days notice. But they said to me straight away, just ring as soon as it goes out the account, and which I did, and it was returned to me within about a minute.
Okay, thanks.
The problem that you're going to have is, if you've got a debit order running off your account, you're going to have to be doing that every month now for the next couple of months, because they're not going to stop the debit order.
The bank can stop the debit order for you.
Yeah, but each month you're going to have to go and reclaim it, or does it, once you've cancelled it, it's cancelled?
No, I've cancelled it completely. So now it's down to my responsibility to make the payments directly to Tower. So I cancelled it completely. The bank doesn't hold any responsibility for any breach of agreements that you have with your direct debits.
Guys, okay, so I think the debit issue is one thing. If you can go to the bank and show that you've sent a letter asking the landlord to cancel the debit order, just that one letter, The bank has an obligation. Whether they do it or not means you might have to go to the banking ombudsman, you might have to go to the banking council, but they have an obligation to stop that debit order and, in fact, to reverse the debit order within reasonable time period. They don't have a choice. They might not do it, but there are people that you can talk to actually force them to do it. That's the first point I wanted to just make in that regard. All right. I'm not certain how you want to proceed on this one. I'm looking for guidance from you.
I was just on something else on that schedule where you've got month 1, 2, 3, 4, 5, 6. At month 4, shouldn't it be 4 months and then 5 months and 6 months?
Yeah, no, I just haven't changed those things yet. I've just been making the changes as you've been speaking. So yes, absolutely. But the real question is, do you want to put in percentages or something else?
I like the percentages in there because it helps for us to do our budgeting and our planning. In my opinion, I like to have something in there so I know what we're working with.
I also like it. I just think that possibly, and it's just an opinion, is maybe to group it into 2 months, 2 months, 2 months, instead of going 20, 30, 40, like, I don't know, just to agree on, but I don't know, it's not important, but I do agree with it, the percentage.
Guys, I think we're not being clever in putting percentages down. It's too early to navigate these waters. It's to commit to this stuff, and we go. I mean, it's April now. Lockdown lifts the 1st of May. The economy is destroyed. You know, things are not going to resuscitate. We're going to be sitting in September. We don't have lockdowns going to continue. People aren't coming into the country, and now all of a sudden, month 5, which is toward the end of the year, that we've got no international trade, and we're now committed to 70% of the rental, and none of us have collected any cash. All we're doing is just kicking the can further down the road by putting these figures in place. Anyway, that's our 2 cents. We don't agree to it,
I think I don't know if Ivor knows the centre, but the Cape Quarter Centre is, I think we've mentioned it once or twice, but I would say it's about 60 to 70% tourist based.
I understand that completely. Guys, this is absolutely up to you. You need to feel comfortable in terms of what we put in here so that you're happy to live with it. We want more people included rather than fewer.
Just leave it as a staggered schedule to be applied to the rental payments, and full stop. And then we can start entering because then the negotiations can start, and then we can start bogging the thing down with red tape. Let's not. I don't think we should try and wrap it up too clearly. I mean, this is going to end up being negotiated on a case-by-case basis. I mean, the principle of what we're doing here is setting a stance to not be bullied. But Carl might want to, Carl's trade is going to be different to ours and to James's. So,
but I think that pulls us into all individually negotiating, which will take us back to the beginning again.
Not necessarily, because I think the stance has been set, and I mean we can still communicate with one another, and and I'd say, guys, drive hard negotiations. I mean, we're sitting in very prime positions at the moment. We really are. I mean, we are not victims here by any stretch.
I'm going to say something that sounds slightly oppositional, and that is this. You've acknowledged that you have no intention of renewing your lease come January, and so you're in a position to be relatively harder and more oppositional than individual tenants who are in fact dependent on the renewal of the lease. And please don't misunderstand me. I'm not in any way. I'm saying your stance is a right stance for your current predicament or your current situation. However, the reality is that the other people or the other tenants on the line don't necessarily have the luxury of alienating the landlord to the extent that, any concessions now will have some kind of comeback down the line. And I'm not saying they would or wouldn't. I'm just saying it's something to consider.
Could we not? But can we not? What I'm saying is, and I agree fully with you. Can we not structure the letter that says in such a way that we're setting a stance, we're looking for everyone to win, but it kind of does have to boil down to a case, again, a case-by-case negotiation. And I'm not quite sure how to do it, because, you know, Carl might want to do a turnover-based rental, which may very well make sense for him to do that, and that's his negotiation. You know, the restaurant industry might want to do it on a more staggered agreement. So I mean, I don't know. I mean, is there a way of structuring this clause in such a way that we're standing together, but we can't apply a specific blanket negotiation on the rental components to each and every tenant, because, you know, everyone's trade dynamics and lease agreements are different.
But I think, though, that, and really, again, it's totally dependent on whether or not you want to negotiate on an individual basis or a collective basis. I think that the contrary is also true, in the sense that we're doing this thing to be able to be in a position to do a collective negotiation, and let them rather assert the fact that they're going to have to do some kind of a distinction, you know, on a company by company basis. I just think, though, that we've got to be discerning about whether or not an individually negotiated as opposed to a group negotiated stance will be beneficial or not, if you understand what I'm saying.
I feel we need to negotiate as a group, but I think if we can't make those percentages that you've stipulated there, that is there not a way we can default to present our turnover, and then if we can't meet those percentages, we go on to a turnover-related rental?
I actually agree with the notion that maybe it's a good idea to actually leave the percentages out and let them make the proposal in that regard. So I'm actually in total agreement with that. In other words, as it looks at the moment.
I would feel a whole lot more comfortable if we were doing this as a group, because if you're going to talk on a case-to-case scenario, they would annihilate, say, me. I mean, already they've given me some very harsh terms and conditions, and yeah, I support it being a group that everyone will be in the same negotiating point. You know, that we're all going to be battling to get our businesses going.
Yes.
I agree with Philip. I think that we should go in April, no rent, May 20%, June 50%, July 75%, or whatever we decide, 30 or 50 or whatever it is. And then we say thereafter, we will each negotiate what we do thereafter, depending what the situation is. But we have to do lockdown and 3 months after lockdown. Otherwise, we're really going to be, I promise you, I think we should give them what they gave us initially, being the 20% for April, but make that for May, because they thought we were going to be back, and the 50% for June, because that's what they offered us anyway. So we know where they stand. They just stood there with, it wasn't based on nothing. It was based on the renewal, but obviously not based on the renewal.
Lana, I agree to an extent, but you want to go back. So let's say we open in May and they want 20% on the 1st of May, but we haven't been trading March and April. So where are you going to get your 20% from to pay for May?
I think that in the lease, it says there that if we are unable to pay, which we're not able to pay, that it's deferred with no interest.
If I can just jump in, sorry, I lost internet for a while, is that I don't think we should put down specific percentages. I mean, what happens if lockdown is phased in slowly and we only able to start trading in the middle of May? I think it's too restrictive. I think the turnover suggestion is a great idea. And I think we can phase it right, sort of make something around the turnover, a certain turnover of whatever we do in that month is agreed on, whether it's individually. But I do think we need to have a collective proposition for them, because that's why we're doing this, and this is why we've put all this effort in. But I think to have specific things for May, 10%, for June, I'm using it hypothetically, 50%. I think that is just really putting a bit of a noose around our necks.
Does anyone see that? See the landlord coming back and being okay with 10%? I don't think they're going to be okay with that. So I think we need to give them some direction as to where we want it to be.
I agree with Philip. We need to give some direction.
Well, I think saying that we'll pay utilities and we won't pay any rent is pretty clear direction to start with. I don't know.
Yeah, I'm talking about for the rest, the 6 months after. You know, they might come back and say, well, okay, we want 80% for every month for the each month thereafter. So let's be clear.
Maybe let's be clear. What I'm saying is for less time. So what we basically going back to what the initial letter said, more or less.
Ava?
Yes.
I just want to make a point there. You said there once lockdown is lifted, the lockdown's probably going to be lifted in like a staggered sort of arrangement. It won't open up because of let's call it the peak in September. I'm privy to some medical documents and understanding what's happening, and we're in this for a long haul. So we really need to keep Section D quite open, saying that, you know, while we're fully closed, we will not pay any rental. While lockdown is partially in effect, we will not pay any rental. And then I think leading up to month 6, after we're fully operational, staggered. I know some people are asking for percentage, some people are asking for turnover rental. I'm not prepared to open my books for the landlord to have a look in. It's not his business, it's mine.
Look, what I've done here is I've
just to tack
made a change.
Sorry, one thing I learned yesterday, just to tack onto the back of what Rodney says. I was chatting to a colleague of mine in Los Angeles, in Irvine. So they went through a lockdown period. They've now moved to social distancing. They reopened all of their beaches. They basically applied a rule of social distancing. No one obeyed the rule, and they put them back down they put certain areas back into total lockdown. So I'm just saying that you know, I'm in full agreement with Rodney as well, because that dynamic could well exist. So we commit pen to paper on the presumption that we all return, you know, happily in May with flowers in the air and tourists in the center. But, you know, the reality is that if, you know, we open for 2 weeks and another full lockdown comes, or there's a social distancing or a civil war, or, you know, goodness knows what goes on. But, you know, yeah, I just think we need to take these dynamics into consideration and keep this proposition. Maybe it'll open-ended at the moment.
So if
I
you
agree
look at
totally.
what I've done here, if you look at what I've done here, you'll see that I say, for this reason, we're requesting a staggered schedule be applied to the rental payments for those 6 months. Full stop. Then, for each month that lockdown is extended, this period of staggered repayments will be pushed out by an equal amount of time, and we leave it at that. We don't talk about percentages. We just leave it at that.
But then if May rental is due the 1st of May, what happens then?
Well, they have to then get back to us, I guess, quickly.
If lockdown,
don't pay it.
Don't pay it. It's agreement. That's simple.
Just don't pay it. You got 60 days.
So, you know, the bottom line is, if the current lockdown ends at the end of April, then the staggered period would kick in if we can have agreement with them.
There is maybe a way to change the wording just for that last sentence where you said for each month that lockdown is extended, maybe put in brackets or something to the extent of, or, you know, or converts to a partial lockdown.
Sure.
Because then at least we're opening the door for further discussions based on, you know, the change in landscape as that happens.
Of course.
You guys must also remember that this is the first open letter for negotiation. So we're not going to come up to an agreement. What we put down now is not going to be agreed on immediately by the landlords. It's just opening the doors of communication to come to an agreement of some sort.
Absolutely. I mean, that's the whole point. So yeah,
but I still don't see them coming back with an attractive offer, like saying 10% for the first month, 20% for the second month. I anticipate it to be like more like 50, 60, 70, or maybe 70, 80, 90%. These guys are hardcore.
So we'd have to negotiate.
So from the emails we've got from them, I can tell you there's no way it's going to be less than 80%. They were quite emphatic with the emails to Peter and I that we pay and they will look at crediting us 20 with potentially subject to their meetings after lockdown, a 20% credit, which it would put off against the upcoming rentals, which is not favorable. So
Carl,
they are no way.
The point is we have to negotiate, and we have to negotiate hard. You know, we know that. Either we're going to have a position to negotiate or we're not. It's that simple.
Yeah.
Right, guys,
that's why I don't know if it's not worth it.
Can I just ask?
No, they might come back with an 80% rental, but then we go back with a negotiation and say, well, we can't pay the 80%. This is what I'm saying, is that this letter is to open up the communication channels with them, to them to understand that all the tenants are standing as a unit and they have a choice to either work with us or not at all.
All right, guys, can I just do this? I do have another meeting to get to now, so can I just ask that possibly on the WhatsApp chat line we complete the process? I mean, we have now discussed, I think, a large proportion of what we need to. That we complete the process and that we actually put the schedule together and get this letter off once everybody, or those people who've agreed or want to be on the schedule will be on the schedule, and those who don't need to be won't be, if I can put it that way. Hello?
Sure.
So I will circulate what we've done so far on the WhatsApp group, and then let's just take it further on that. Sorry about this. I'm just back to back at the moment with different shopping centers. Is that okay, everyone?
Thanks, Ivor.
Thank you, guys.
Yes, thank you.
Thank you very much.